But before we go any further with any of these cases we're covering here on Law and Crime, let's get you caught up to speed on the top stories making headlines.
Here are today's top crime stories trending on lawandcrime.com and across the country. Convicted MMA star War Machine reportedly apologized to his ex after finding Jesus in prison while serving time for brutally assaulting her. Jonathan Copenhaver, who also goes by War Machine, was convicted of sexual assault, coercion, battery by strangulation, kidnapping, and several other charges in connection with the attack on his ex, porn star Christy Mack. The ex-MMA star issued the apology in an upcoming documentary. Copenhaver is serving a life sentence with a possibility of parole when he's 71. A 3-year-old child is being credited with helping state troopers in New Scotland, New York, bust 2 adults by handing over a bag of marijuana. 26-year-old Scott Hill and 33-year-old Megan Carl were arrested after troopers were alerted to the stash during a traffic stop by the child. It's unclear of the child's relationship to Hill and Carl, and the child is now in the custody of a relative. Hill and Carl now face a charge of child endangerment, with Hill facing an additional marijuana possession charge. Authorities in New York City released surveillance footage of a man hurling liquor bottles and beating employees at 2 separate stores with the hopes of identifying the man. The robber first struck at Seward Park Liquors, beating an employee who refused to hand over money. The suspect was able to make off with $200 before attacking employees at Reno Fashion, injuring 2. Police are now looking for a bald man believed to be between 45 and 60 years of age. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
All right, to break down some of those top crime stories, with me is Elura Nanos, attorney. Of course, you've seen her before. You'll see her again here on Law and Crime. Elura, good to see you this morning.
Thanks, Aaron. Good to see you, too.
Okay, so what do you make of this liquor store robbery situation? Why not just go for the booze if you're going to rob a liquor store? Surely there were bottles that were worth more than $200.
Yes, probably, but I mean, it would also require that he knew which bottles were worth $200, and then he'd have to go and sell them to someone else. So I guess it was just easier to make off with the cash in the register, regardless of how violent he needed to become before doing that.
Yeah, I mean, this is a pretty hardcore attack. We're watching it again here. I mean, these are direct punches. What kind of charges are we talking about here? Are we talking about assault? We're talking about robbery? Where does this go?
Yeah, New York, this is certainly assault. This is certainly robbery. It may even be, attempt for something more serious. I just want to point out that, it's hard to see because that video is pixelated where the victims' faces are. But in the store, the second one, not the liquor store, but in that second store, one of the victims is an 88-year-old woman, and the other is a man who I think was
66.
Right, 66. I mean, that looked like a pretty severe attack. So, depending on the nature of the injuries that these folks sustained, that really is going to tell us what degree of crime this is. I will say this, though, that just from a prosecutorial standpoint, the fact that the perpetrator of the crime did not enter the liquor store with a weapon, it is relevant. Picking something up off the counter, picking a bottle up, is legally different than maybe going in with a gun. But I mean, at the end of the day, I think the nature of the injuries and the severity of the attack is going to be very important in charging him.
I agree. That's yet to be seen. We will keep an eye on it, though. Elura, I know we're going to be back in a couple of minutes to break down the Liggins case, so let's switch over there now. This is our live trial today, Iowa versus Stanley Liggins. This is a Quad Cities area murder case dating all the way back to 1990. The defendant, of course, has been tried now 3 times related to the death of 9-year-old Jennifer Lewis. We're going to start, because it's helpful at this point, to dial back to some of the opening statements. Let's listen to how the prosecution sold this case. We've been talking here on Law and Crime about whether or not the testimony matches the promises, because so many of the witness identifications of the defendant are really, really shaky. We have a witness saying that the witness saw a vehicle in the area where the girl's body was found, but that's really all we know. We know it was a red car. We know the trunk was open. We know somebody was standing there. The witness couldn't identify the race of the individual, couldn't identify a height, whether the person was slight or stocky. So many details are missing from that witness so-called identification. Is it really the defendant that we're talking about here? Then we've got another witness who said that she saw the fire, believed to be the fire that was set on the little girl's body. But she didn't see much beyond that, other than someone fleeing the sea wearing white shoes. No further description. How are prosecutors trying to point the finger directly at this defendant? Let's go back to opening statements and try to make sense of things. And here we see the prosecutor trying to connect the dots with the available evidence and claiming, at least in the prosecution's theory, that that evidence points directly to the defendant, Stanley Liggins. Elura Nanos is with me here on the Law and Crime Network. She's an attorney who writes for us, appears for us, and today is appearing from the comfort of her own home. Elura, how nice of you to join us with probably your bagel just off camera. But, okay. Stanley Liggins, we keep hearing about this car. Is the car enough to connect this guy to this crime?
Well, I think that a lot comes down to the sort of motivation of the jury in this case. I think it can be. And given that, this case has gone to trial twice, there's been convictions both times. So I think it very well could be enough. Let's remember that this is a case with a child's victim. It is very upsetting. And I think that even though so much time has passed, this is the kind of case that a jury wants to convict someone for. And I think that whenever you have a case where the facts just are the type that the jury wants justice for that victim so much, I think that as long as it's rational to believe that that's enough evidence, I think it has a very strong chance of being enough evidence.
Look, is it rational or is it proof beyond a reasonable doubt? What's the burden of proof here?
Yeah, is proof beyond a reasonable doubt. And I think that, there are cases and sets of facts where this wouldn't be enough to constitute, beyond a reasonable doubt. That being the case, I don't know that the lack of evidence is going to stand in the way this time, just because the underlying tones of this case are such that the jury is going to want to convict.
Yeah, I understand, Elura. Okay, we're going to be back in a couple of minutes to talk a little bit more about this here on the Law and Crime Network. We will return with further discussion about the Stanley Liggins case in just a couple minutes. And, of course, underneath all that fire was the body of victim 9-year-old Jennifer Ann Lewis. Turned out that she knew the defendant in this case, Stanley Liggins. One piece of evidence that's not going before jurors in this case, and which was indeed part of the reason why one of the earlier trials for this defendant was flipped, is that the defendant knew the victim's family because he was dealing cocaine, apparently to them or involving them. Elura Nanos of Law and Crime is with me here today. Elura, so the fire is a key piece of this. It seems that the prosecution's putting every detail in, but does any of this really link this defendant to this crime?
Well, so far, not really. But I will say that what we heard from the firefighter who had been on the scene is really important, because so often in these old cases, we don't have a clear cause of death, or we don't have anything even remotely amounting to eyewitness testimony. And here, while the evidence maybe isn't so strong linking the defendant to that scene, the evidence that shows what happened to this little girl and how it happened and how she died, it could not possibly be any stronger. So you're right that the weakest link here is linking the defendant to the scene, and we'll have to see if we have enough coming up on that.
I agree. Okay, so we're going to continue to move along here, talking about the Liggins case. One issue here is, why have this retrial if so much of the testimony is not live testimony, but rather readback testimony? I mean, certainly it allows prosecutors and defense attorneys to sort of go through the record with a scalpel or an X-Acto knife and cut out what they want and what they don't really want. But after these couple of live witnesses, it's just been readback after readback after readback.
Yeah, certainly it makes a less interesting set of testimony when we're doing mostly readbacks. However, what are the prosecutors supposed to do here? At the end of the day, there is a 9-year-old homicide victim. They have to retry this case, and basically they have to take what they have, take the evidence that exists, and put their best foot forward, and try to remedy any errors that happened in the underlying trial, and hopefully that they get another conviction.
Yeah, okay, so they're going to try to do that. They're marching along with all of this readback testimony, but let's talk about cross-examination here. It's hard to cross-examine a record. It's impossible to cross-examine a record. This defense team is stuck dealing with the work of the previous defense team. That's what they have to go on. What if they really want to probe into whether or not the witness's memory has changed? What if they want to really probe into, hey, wait a minute, you testified this the first time around. Is it really, you testified a different way this time around. What if things don't match up? They don't have that opportunity here.
Right. I mean, I think that is, that's the problem, certainly, with having retrials, decades later, and the defense is, going to be stuck with that, and they're going to have to make the best of what's there to put on their case. But I think that is going to be a predictable and repetitive problem in this case, that they can only ask what they can ask, and they're not going to have that same opportunity that would have been for a real good live cross-examination. Yeah,
I mean, some of the witness identification in this case is rather weak, but bottom line, we have another piece of key evidence here that we haven't even dived into yet. That is that the defendant admitted in the midst of his interrogation that he was lying. He backpedaled at one point. He also volunteered information about the victim's clothing. We will be back with more live discussion of the Liggins case in a moment. We are waiting for live testimony to pick back up in the Stanley Liggins murder trial out of the Quad Cities in Iowa. We expect that to happen about a half an hour from now. In the meantime, we're dialing back to some of the prosecution's promises as the state kicked off this case. One thing that the state said is that the defendant's own words would help convict him. Elura Nanos is here with me to break this point down. Elura, we were saying before the break, the defendant admitted in the midst of an interrogation that he lied to police. He also volunteered information about the victim's clothing, which the interrogator thought was a little bit funny. Now, those 2 points, when you couple it together with the other evidence, just might be enough for the prosecution to say, look, this guy's got a guilty conscience. He's letting information slip that he shouldn't really know. The defense can turn around and say, wait a minute, he knew the victim's family. He knew this stuff. Maybe that was him in the car talking to her before she disappeared.
Certainly that's true, but I do think that evidence that a criminal defendant lied, for whatever reason, I think that evidence is always going to be extra valuable. And let's keep in mind that in this case, although the jury has not been told the specifics of the 2 previous trials and why those convictions have been overturned, the jury is allowed to be told that there were 2 previous trials. So if the jury has any common sense, they would know that he must have been convicted, because if he had been acquitted, then there wouldn't be subsequent trials. So I think that all of that is going to weigh together. And I think that it may make small pieces of evidence, like knowing about the victim's clothes or like a lie about something relatively minor, might make it have more meaning in this case.
I agree. Look, I mean, the defendant lying is not going to help in any way for the defense here. Add that together with this other testimony about the vehicle and whatnot. The victim approaching a vehicle believed to be the defendant's vehicle, at least in the state's theory of this case. That's going to be very, very damaging for the defense. We're going to listen to some of that transcript testimony from the victim's neighbor at this point. Diane Pemberton talked about seeing this red car in front of the house. And this is the red car that the state has said is really key evidence in this case, because they believe it to be a vehicle that the defendant had access to. Let's listen to some of her transcript readback testimony. So the state really zeroing in on whether or not that witness, Diane Pemberton, whose words we're hearing through a readback of previous testimony there, the state really keying in on whether or not she identified the defendant himself, Stanley Liggins, and the link between the vehicle, this burgundy or red color car, and the victim, Jennifer Ann Lewis, approaching that vehicle in the evening that she disappeared. Elura Nanos still with me here at the Law and Crime Network. So this link is getting tighter and tighter and tighter as we listen to more and more of these witnesses, and they're adding up in our minds. They're adding up in the minds of jurors, I'm sure.
Absolutely. And I'll say that very often when you hear testimony that's being read back, often it does have the ring of being sort of disjointed and
Manufactured,
yeah, it does. And
etc.
I'm not getting that here. I'm actually getting pretty credible recollection about what the car looked like, what happened, what time it was, and why she knew those details.
I mean, maybe out of this witness, yes, but we had some other witnesses who were being read back yesterday. They said, well, I saw a red car. It had 4 doors. The trunk was open. There was a man about 6 feet tall standing near the trunk. And then when asked what that witness didn't see, well, I couldn't discern the individual's race. I couldn't discern whether the individual was stocky or thin. Couldn't pick out a plate number. Didn't see any fire or anything like that. Couldn't pick out anything about the taillights. Well, we just heard the prosecution say that this car had very distinctive taillights. We heard that during the opening statements, but the witness who saw it near the scene where this girl's body was later found didn't mark anything about the taillights and wasn't sure if the car that was being shown to that witness in police photos was indeed the one witness near the scene with the trunk open. So there's a couple of pluses in my plus column for the state there and a lot of minuses in the minus column.
Absolutely. I think that missing those details, the jury will notice that they're missing those details. So although maybe this witness did a kind of a tighter job on it, I think that those other identifying details being missing, I think that is going to weigh heavily on the jury's mind.
Yeah, so many witnesses adding up in this case, and each one does present a little bit of a different nugget. And sometimes the way the state has to present the case like this is to put a gold coin here and a gold coin here and a gold coin over there, and then lead jurors through those bits of testimony, taking jurors through picking up those little coins along the way and say, hey, look, folks, this witness didn't see everything, but they saw one little important sliver here, another little important sliver over there, and add it all up, and it results in guilt. That is what I expect the state to say when the state closes this case up. Of course, we're not sure exactly, folks, what the defense is going to do, because if memory serves me right, the defense waived its shot at an opening statement at the beginning of the case. That might come at the beginning of the defense case in chief when it picks up we hear on Monday. A reminder, folks, that we have special programming coming up from 1 to 2 o'clock today. A Brian Ross Investigates special here on the Law and Crime Network, 9/11, Are We Safer? This is going to break down a number of key elements. The first segment will involve expert discussion about whether we as a country are safer today than we were on 9/11. Also, still more victims, the lingering legal effects of the additional victims of 9/11, saying that toxic air and dust resulted in additional injuries. That and more in that special segment. We will be right back. Testimony there in the Stanley Liggins case out of the Quad Cities from Don Schaefer, a lead investigator. He's talking about a garbage bag that he believes that the victim, 9-year-old Jennifer Lewis, was burned in and left near an elementary school back in 1990. Elura Nanos is still with me here on the Law and Crime Network. Elura, so one of the key questions here is what's up with this garbage bag? Apparently it was in a specialized garbage bag, and the question that this investigator was trying to dig into is whether or not it may have been the type of garbage bag used by some contractors in an area that was critical to the defendant. So he just goes over to Rock Island, Illinois, and starts digging around, trying to dig up information about this. No warrant, no nothing. Does this seem a little suspicious to you?
I don't know that it seems suspicious. It actually sounds like aggressive and pretty good detective work. He's digging into an important piece of evidence. Granted, he's doing it in a way maybe that's a bit off the beaten path, but it doesn't really sound like it was the type of investigation that needed a warrant. To me, it sounds like just good detective work.
Okay, so why not get a warrant in this situation? You're heading out of your jurisdiction. You're heading into another state. That would have taken time. Why not get a warrant?
I think that's a good question, because certainly he could have gotten a warrant. However, let's keep in mind that whenever investigators get warrants and show up with a warrant, it changes the dynamic of any kind of investigation that they do. So if he were to run into, other people and needed to present the warrant, it changes the reaction of the people who the warrant is presented to. So in this case, it may have just been that he just thought it was better and easier to just do it without a warrant. And it doesn't necessarily sound like the type of thing that might have required a warrant. So, I think it may have just been kind of detective instinct to do it without a warrant. Although, in retrospect, when you're looking at this through the eyes of a prosecutor, at that point, it may have been better for him to have done it sort of by the book.
It may have been, but bottom line, this evidence got into the court, so the judge must have ruled exigency. In other words, that these garbage bags may have been in the process of disappearing because they were believed to have been used by a roofing contractor. Hey, look, we heard the detective say, look, I thought maybe this stuff would be disappearing. Maybe the contract would wrap up. I had to get over there right away, drove over myself because I thought that this stuff might be leaving the scene and I would miss critical evidence. That is exigency. My guess is the judge turned around and said this evidence comes in, and that was the legal reason why. We're going to talk a lot more about the Stanley Liggins case when we come back here on the Law and Crime Network. We are anticipating live testimony to pick up any moment. We see people filtering into the courtroom as we speak. We're hoping to bring you there live any moment from now. We will be back after this quick break here on the Law and Crime Network. Testimony there from one of the actual responding officers who went to the scene where 9-year-old Jennifer Ann Lewis was found dead in 1990 near an elementary school in the Davenport, Iowa area. We're going to be back with more live testimony in the Stanley Liggins murder trial, the case you were just watching. But an important programming note. This afternoon on Law and Crime, Chief Investigative Reporter Brian Ross brings you a special report, 9/11, Are We Safer? He will break down the big questions on this anniversary of 9/11, including whether the war in Afghanistan was a success or a failure, whether justice is truly being served at Guantanamo Bay, and how those suffering from the massive clouds of toxic dust stirred up that fateful day are fighting for their lives medically and legally. That is all this afternoon from 1 to 2 p.m. here on Law and Crime. When we come back here, though, we're going to be bringing you more live testimony from the Stanley Liggins case in Iowa. Stick around. You won't want to miss anything that's next. We will be right back. We are talking about the 1990 murder of 9-year-old Jennifer Ann Lewis in the Quad Cities area of Iowa, and we are in some evidence that just brings a human face to this crime. Elura Nanos with me here on the Law and Crime Network. We're seeing this poor 9-year-old girl's schoolwork with her fingerprint on it. They had to take her prints from her autopsy to match it up to get an identification. This is one element of this story that we've not yet heard.
Yeah, and forensic evidence like fingerprint analysis, like testimony about how fingerprints work and how the science behind it works, runs the risk of being relatively dry. But in this case, the fact that the victim was a little girl really is woven through every possible aspect of every bit of evidence. So when we're talking about how did they match the fingerprints, we have her homework, which is heartbreaking. When we have evidence about how they matched with the body that was found, the witness explained how there wasn't enough tissue left on one of her hands. All of these things culminate for anyone listening to really paint an extremely emotional picture of what's going on here.
It's one thing to look at the old photos and whatnot, but memories and photos fade with time. This to me is the time in this case when we have seen a tangible link to 9-year-old Jennifer Ann Lewis, the victim in this case. Her schoolwork, the words that she was circling in that assignment, her fingerprint next to them, that's what they needed to make the link.
That's exactly right. I mean, in addition to the fact that there's a major emotional component to this, there's also, it's a very, very solid piece of evidence because, of course, we're making a positive identification of who the victim is. And it's a scientific match. It's not something that's really subjective. So it becomes a really critical piece of information in addition to being very emotional.
And of course, these days, a lot of this would probably be done through DNA rather than just simply for going rather to the schoolwork to get a fingerprint. This, again, another piece of evidence that brings us back to 1990.
Yeah, that's right. I think that this case has that feel of sort of being frozen in time. And I think that in many regards, when we go back to fingerprint evidence and we're going away from DNA science, there may be some jurors who are actually more comfortable understanding fingerprint science because it's not nearly as confusing as DNA evidence is. So that may actually weigh in favor of the prosecution's case.
Elura Nanos, I know you need to hit the road, and we need to take a break. So, Elura, good to see you again. Wish it was here across the table.
Thanks, Aaron. I'll be in soon.
Okay. We're going to take a quick break here on the Law and Crime Network. We will be back with more, though, right after the break with live testimony in the Stanley Liggins case from Iowa.